asset protection results. The trust owns the home legally, but you retain the right to live there and may have some input on future decisions about the property. The assets are managed by a trustee, and you can still benefit from the assets by remaining in your home. Trust-based home protection often works better for families who want more control over future decisions or who have complex family situations. Like life estates, the 5-year look-back period must pass before the trust provides protection from Medicaid's asset counting rules. Many families consider joint ownership with adult children as a simpler alternative to life estates, but this approach creates significant risks that often outweigh the benefits. When you add your children as joint owners of your home, they immediately acquire ownership rights and potential liabilities. If your child gets divorced, faces a lawsuit, or declares bankruptcy, their ownership interest in your home could be at risk. Joint ownership also triggers potential gift tax consequences when you add children to the deed. The IRS treats this as a partial gift of a home's value, which might require filing gift tax returns and could affect your lifetime gift tax exemption. Additionally, your children lose the stepped-up tax basis they would receive if they inherited the home after your death, potentially creating higher capital gains taxes when they eventually sell the property. I worked with the Morrison family who successfully protected their home using a life estate strategy. The parents owned a home worth $450,000 when they were both 74 and in good health. We created a life estate that allowed them to continue living in the home while transferring ownership to their 3 children. 6 years later, when Mrs. Morrison needed nursing home care, the home didn't count as an available asset because the life estate had been in place longer than the 5-year look-back period. The family qualified for immediate Medicaid coverage while preserving the home for the children. Home protection planning fits into your overall asset protection strategy by addressing your largest single asset while coordinating with protection of financial assets. Many families implement comprehensive plans that protect both their home and savings using complementary strategies. The home might go into a life estate or trust arrangement while retirement savings get protected through different trust structures. One of the biggest misconceptions I encounter is the belief that homes are automatically protected simply because someone lives there. Families assume that primary residences can't be touched by Medicaid, but this assumption ignores the estate recovery process that occurs after death. While you might keep your home during your lifetime, the state can still claim it after you pass away to recover long-term care costs. The family home can be completely protected with the right advance planning, but protection requires understanding the specific rules that apply to your situation and implementing appropriate strategies before you need care. Both irrevocable trusts and life estates require the 5-year look-back period to pass before providing protection, which means families need to act while they're still healthy and planning ahead. But what happens when families don't have 5 years to plan ahead? What options exist when the health crisis has already begun and time is running short? Crisis planning. What to do when time is short. I know some of you watching this are thinking this is all great information, but what if it's too late for advanced planning? What if your spouse is already showing signs of dementia, or maybe they've already been diagnosed and you're looking at nursing home care in the next few months? The reality is that some families find themselves in crisis situations where they need immediate help. And while your options are much more limited than they would be with advanced planning, there are still legal strategies available to preserve some family wealth even when time is running short. Let me be honest with you about what happens when you're in crisis planning mode. The 5-year look-back period becomes your biggest enemy because any significant asset transfers you make now will likely trigger penalty periods when you apply for Medicaid. This means you can't simply give money to your children or transfer your house to them without facing months or even years of Medicaid ineligibility. The ideal planning window has closed, but that doesn't mean you're completely out of options. The first strategy available in crisis situations is what we call legal spend-down methods. These involve using your assets to pay for legitimate expenses that Medicaid considers acceptable ways to reduce your countable resources. The key is that these expenditures must be for goods or services that provide fair market value in return. so Medicaid doesn't treat them as improper transfers that trigger penalties. Medical expenses represent the most straightforward spend-down opportunity. You can pay for health insurance premiums, prescription medications, medical equipment like wheelchairs, or hospital beds, outstanding medical bills, dental work that's been postponed, hearing aids, eyeglasses, and any other legitimate healthcare costs. These payments reduce your assets while purchasing necessary medical care, making them completely acceptable to Medicaid. Home modifications often provide excellent spend-down opportunities while improving safety and accessibility. Installing wheelchair ramps, widening doorways, adding grab bars in bathrooms, replacing regular bathtubs with walk-in showers, improving lighting throughout the house, and adding stair lifts all count as legitimate medical expenses. These modifications not only reduce countable assets, but also might allow someone to remain at home longer before needing nursing home care. Medicaid-compliant annuities offer a more sophisticated crisis planning tool, but they must be structured very carefully to comply with Medicaid rules. A Medicaid-compliant annuity converts a lump sum of cash into a stream of monthly income payments. The annuity must be irrevocable, non-transferable, and actuarially sound, meaning the payment period cannot exceed your life expectancy based on Social Security Administration tables. The annuity strategy works particularly well for married couples where the community spouse can purchase an annuity with excess assets. The monthly annuity payments become income for the community spouse, potentially increasing their monthly maintenance allowance while removing the principal from Medicaid's asset calculations. However, these annuities must name the state Medicaid program as a beneficiary, which means if you die before receiving all payments, the remaining balance goes to the state rather than your family. Caregiver agreements represent another crisis planning option that many families overlook. These are legally binding contracts where you pay a family member or friend to provide personal care services. The payments must be for care provided after the agreement is signed, and the compensation must reflect fair market value for the services provided. This strategy allows you to spend down excess assets by paying for needed care while keeping the money within your family. A proper caregiver agreement requires detailed documentation of the services provided, regular payment schedules, and rates that match what you would pay professional caregivers in your area. The caregiver must report this income on their tax returns, and the agreement should specify exactly what care services will be provided, from assistance with daily activities to transportation to medical appointments. Prepaid funeral trusts offer another spend-down opportunity that families often forget about. You can prepay funeral expenses for yourself and your spouse without these payments counting as improper transfers. Many funeral homes offer irrevocable funeral trusts that allow you to pay in advance for funeral services and burial expenses, removing these funds from your countable assets while ensuring your final arrangements are handled according to your wishes. Paying off existing debts represents another acceptable spend-down strategy. Outstanding credit card balances, personal loans, car loans, or even mortgage payments can be paid off using excess assets without violating Medicaid's transfer rules. The key is that these must be legitimate debts that you're legally obligated to pay, not informal arrangements with family members. The importance of professional guidance cannot be overstated when you're in crisis planning mode. Elder law attorneys who specialize in Medicaid planning understand the intricate rules and can help you navigate the limited options available. They can also help you avoid costly mistakes that could make your situation worse rather than better. What makes crisis planning particularly challenging is that you're operating under extreme time pressure while dealing with complex legal and financial rules. Families often feel overwhelmed by the immediate need for care while simultaneously trying to understand complicated asset protection strategies. Professional guidance helps ensure that whatever strategies you implement actually work within Medicaid's requirements and don't inadvertently create additional problems. The key takeaway is that even in crisis situations, there are legal strategies available to preserve some family wealth. While you can't achieve the comprehensive asset protection that's possible with advanced planning, you can still make strategic decisions that save your family thousands of dollars. Crisis planning requires quick action, careful implementation, and professional guidance, but it can provide meaningful financial protection even when time is running short. But whether you're planning ahead or dealing with an immediate crisis, the most important step is taking action rather than hoping the problem will somehow resolve itself. Taking action, your step-by-step protection plan. The comprehensive protection plan I'm about to outline will help you implement these strategies effectively and preserve your family's financial security. Every family situation is unique, but the fundamental steps remain consistent regardless of your asset levels or current circumstances. The first critical step involves conducting a comprehensive assessment of your current vulnerability to nursing home costs. You need to calculate your total countable assets for Medicaid purposes, which includes all bank accounts, investment accounts, retirement accounts, CDs, savings bonds, and any other financial assets that Medicaid considers available resources. Don't include your primary residence, one vehicle, personal belongings, or prepaid funeral arrangements in this calculation. The number you arrive at represents what's at risk if you need nursing home care without advanced planning. Research the actual nursing home costs in your specific area by calling several facilities near you and asking about their private pay rates for the level of care you might need. Don't rely on national averages because costs vary dramatically by location. A nursing home that charges $8,000 monthly creates different planning urgency than one charging $15,000 monthly. Consider your family health history and current health status to estimate your potential need for long-term care. If your parents or siblings require nursing home care, if you have chronic health conditions, or if you're already experiencing mobility or cognitive issues, your planning timeline becomes more critical. Remember that 70% of Americans over 65 will need some form of long-term care services. So planning isn't just for families with obvious health risks. The second essential step requires gathering comprehensive documentation that supports both protection planning and eventual Medicaid applications. You need 5 years of bank statements for all accounts, 5 years of investment account statements, 5 years of tax returns, documentation of any property transfers or gifts during the past 5 years, current property deeds and titles, insurance policies, including life insurance and long-term care coverage, and documentation of any trusts or other estate planning documents you currently have. This documentation process often reveals financial transactions that families forgot about, but that could create problems under Medicaid's look-back rules. Large withdrawals, transfers between accounts, gifts to family members, charitable donations, and other transactions all need to be documented and explained. Many families discover they made transfers during the look-back period that could trigger penalty periods if they don't implement corrective planning strategies. The third and most important step involves consulting with an elder law attorney who specializes in Medicaid planning rather than attempting to navigate these complex rules on your own. The investment required for professional planning varies based on your asset levels and the complexity of strategies you implement. Basic Medicaid planning consultations typically cost between $500 and $1,500. Simple trust planning might range from $3,000 to $8,000. Complex planning involving multiple trusts, property transfers, and ongoing management could cost $10,000 to $20,000 or more. However, these planning costs represent a fraction of what nursing home care costs over just a few months. If professional planning saves your family even 6 months of private pay nursing home costs, the investment pays for itself many times over. Families who spend $15,000 on comprehensive protection planning often preserve hundreds of thousands of dollars in assets. The timeline for implementing protection strategies depends on which tools you choose and how much lead time you have before potentially needing care. Irrevocable trusts require the full 5-year seasoning period to remove assets from Medicaid's reach. So families typically implement these strategies in their late 60s or early 70s while they're still healthy. Life estate arrangements for home protection also require the 5-year look-back period, but can be established relatively quickly once you decide to proceed. Family communication represents one of the most critical aspects of successful protection planning. Your adult children need to understand